27th episode of the SCC Online Weekly Rewind, where we curate the most important and interesting stories to keep you abreast of the latest developments in the field of law. Hi, I'm Nilufer Bhateja, and in this week I have brought highlights of some recent significant updates on the Supreme Court, the High Court, and some legislation updates. Let us begin with some news of the Supreme Court. A division bench comprising of L. Nageshwara Rao and S. Ravindra Bhatt justices upheld the arbitration award of Rs 2782 crores plus interest made by the arbitral tribunal in favour of Delhi Airport Metro Express Limited. The Supreme Court reversed the judgment of the division bench of the Delhi High Court, which had interfered with the tribunal's award. While so deciding, the Supreme Court also observed that there is a disturbing tendency of courts setting aside arbitral awards after dissecting and reassessing factual aspects of the cases to come to a conclusion that the award needs intervention. While addressing the matter wherein a passenger suffered loss and agony due to the delay in arrival of a train, the Supreme Court upheld the decision of the NCDRC granting compensation to the passenger as no evidence was led by the railways explaining the delay or late arrival of the train. The railways were required to lead the evidence and explain the late arrival of the train to establish and prove that the delay occurred because of reasons beyond their control. The court also observed that these are the days of competition and accountability. If public transportation has to survive and compete with private players, they have to improve the system and their working culture. While upholding the central government's order extending the tenure of the incumbent director of enforcement, Mr. Sanjay Kumar Mishra, for a period of 1 year, the Supreme Court held that there is no fetter on the power of the central government in appointing the director of enforcement beyond a period of 2 years. Interpreting Section 25 of the Central Vigilance Commission Act of 2003, which prescribes the minimum tenure of the director of the enforcement, the Supreme Court observed that the words not less than 2 years cannot be read to mean not more than 2 years, and there is no fetter on the power of the central government in appointing the director of enforcement beyond a period of 2 years. The Supreme Court set aside the judgment of the Aurangabad bench of the Bombay High Court, wherein it was held that the reservation of the office of the mayor for the Dhule Municipal Corporation for backward classes or OBC for a second term, coupled with the fact that there has been no reservation for the scheduled caste category, amounted to the violation of the rotation policy. Explaining the rules for interpretation of a statute, the Supreme Court said the court will have to prefer an interpretation which makes the statute workable, the interpretation which gives the effect to the intention of the legislature will have to be preferred. The interpretation which brings about the effect of result will have to be preferred than the one which defeats the purpose of the enactment. The Supreme Court found itself at pains to note that the order that was passed by the Allahabad High Court granting bail to murder convicts lacked clarity as to which part of the judgment and order could be said to be submissions and which part could be said to be the findings or the reasonings of the court. Observing that writing a judgment is an art, though it involves skillful application of law and logic, the Supreme Court said that it is very unfortunate that by this judgment we are required to observe the importance of the judgment, the purpose of the judgment, and what should be contained in the judgment. In a petition that was filed by an advocate seeking to stall the elevation of a judicial officer as a judge of the Telangana High Court, the Supreme Court said that the petition was a gross abuse of the process of law and also imposed cost of rupees 5 lakh on the petitioner. The Supreme Court said that it was surprised at the brazenness of the petitioner now filing a petition under Article 32 of the Constitution. The court observed that we are surprised as the brazenness of the petitioner now filing the present petition under Article 32 of the Constitution of India, the aforesaid being the finding against him to now somehow see that the elevation of the Registrar General does not take place on account of these proceedings initiated by the petitioner. This is a gross abuse of the process of law. While observing that litigants are compelled to accept the wrong orders in view of inaccessibility to New Delhi and the exorbitant expenses towards engaging a counsel, the Madras High Court has emphasized that when approaching the Supreme Court by a common man remains in dreams only, it would amount to denying justice. Justice Kuruba Karan further made a very significant point that Supreme Court is a custodian of rights of not only the litigants but also the entire population. The time has come to establish the benches of the Supreme Court at other places apart from New Delhi. When people are aware of their rights, they should also have accessibility and affordability to reach every level of the hierarchy of courts. A retired judicial officer went on a family tour, and during the said tour, he fell seriously ill and consulted with the doctor in that city. Further, his wife also fell ill and got treated in the same city. Since both the judicial officer and his wife were outside the state of Tripura, they could not obtain referral certificate from the state standing medical board, and while claiming the bills for treatment, objections were raised. To this, the High Court opined that it would be an absurdity for the retired judicial officer and his wife to return to Agartala for the referral certificate from the competent medical board. The court observed that human life is precious. Article 21 of the Constitution of India enshrines the right to life, which includes the right to health. To determine the emergent and immediate exigencies, the authorities concerned must be rational to each and every separate and variable circumstancing, following the Wednesbury's principle of reasonableness, so that it does not shock or hit the conscience of the court. In addition, with utmost humane touch. In a matter wherein a judicial assistant sought voluntary retirement due to his medical condition, the court has observed that, in view of the Central Civil Services Pension Rules of 1972, the government servant at any time after he has completed 20 years of qualifying service may give a notice of 3 months to retire from the service. While addressing a petition seeking a direction for issuance of a joining letter for joining the pre-commission training at the Officers Training Academy at Chennai, the Division Bench of Justices Manmohan and Justice Naveen Chawla made a very significant observation that mere acceptance of resignation may not be sufficient to consider the creation of a vacancy for being filled up from the cadet in the wait. The Delhi High Court has transferred the investigation into death of an under trial prisoner Ankit Gujjar lodged in Tihar jail to the Central Bureau of Investigation. It has been alleged that Ankit Gujjar was brutally beaten by the jail officials, and despite PCR calls and messages, neither was any effort made to save Ankit, nor complaint lodged, nor FIR registered. It has been alleged that Ankit Gujjar was long harassed by the officials of Tihar jail as he was unable to meet the regularly increasing demands of money made by them. The court said that if the allegations are correct, it is indeed very serious offence that requires in-depth investigation to unearth the manner in which the alleged extortion was being carried out in the prison. Further, an investigation was required as to not all who committed the offense of brutally beating Mr. Gujjar but resulting in his death has to be carried out, but also the role of the jail doctors in not providing proper treatment at the right time also has to be ascertained by a proper inquiry. While allowing a person involved in an NDPS case to travel abroad to pursue higher studies, the Jammu and Kashmir and Ladakh High Court has noted that the charges against him was not so grave, and further observed that the petitioner cannot be denied the right to go abroad to pursue studies only on the ground that he is involved in a criminal case. Looking at the gravity of charge and the young age of the petitioner and his quest to acquire quality education, the request appears to be genuine. Squashing the FIR registered against a journalist for publishing the news report disclosing an incident of police brutality, the Jammu and Kashmir and Ladakh High Court has observed that the mode and manner in which the improved FIR has been lodged clearly reflects the malafide on the part of the respondents, as the respondents could have given their version by similar mode, but they chose unique method of silencing the petitioner, and it is undoubtedly an attack on the freedom of the press. Considering a writ petition where gallantry award was presented to the awardee after more than 3 years, the Himachal Pradesh High Court has said that delay in the conferment of gallantry awards should be deprecated. The High Court observed that by promoting the acts of bravery and courage, the gallantry awards are made for ensuring that the spirit of bravery of the recipients of the awardees must be honored in ceremonial functions of the Republic Day or the Independence Day. The National Company Law Tribunal, while addressing appeals under Section 421 of the Companies Act, have stated that there is no bar in merging an unhealthy company with a healthy company to come over a crisis. There was no need perhaps to pass this specific direction. The Central Board of Direct Taxes (CBDT) has decided to further extend the due dates of filing of income tax returns and various reports of the audit for the assessment year 2021-22. The last date for filing income tax return has been extended till 31st December 2021. The Department of Information and Publicity Goa has implemented the free water scheme for all individual domestic consumers with effect from September 1st, 2021. Further, it is also informed that in order to implement the scheme, the water supply bills for the water charges up to August 31st, 2021 will be issued by the Public Works Department for all its consumers as informed by the Department of Information and Publicity. A new law has been passed by the New York government which aims to reduce the greenhouse emissions and air pollution from transportation sector. Under the new act, the new passenger cars, trucks, off-road vehicles and equipment that is sold in New York are targeted to be zero emissions by the year 2035 and new medium duty and heavy duty vehicles by the year 2045. The Act also seeks to develop a zero emissions vehicle development strategy by the year 2023. SEBI has notified the certification requirements of associated persons functioning as the principal officer of portfolio manager, such as such persons must obtain certification from the National Institute of Securities Markets by passing the NISM Series 21B. The portfolio managers must ensure that all such persons who obtain the certification by passing the NISM Series 21B within 2 years from the date of this notification. The question for this week's SCC online quiz was judgments from how many historical courts are covered in SCC online and which is the earliest reported historical case on SCC online. The answer to this question is that SSC Online has 14 historical codes in its database, and the earliest historical case is Kalumal versus MT Chahindi, cited as 1898 SSC Online Lahore 1. Winners of this quiz are Tushar Anand and Ashkrit Tiwari. Congratulations to both the winners. Thank you for watching. Stay tuned for next week's updates.